the European Convention on Human Rights would become directly effective in the United Kingdom. The convention itself is much older than that. It goes back to 1950, and the architects of the convention, well, the lawyers who wrote it, were mostly British. But although the United Kingdom was one of the first signatories to the convention, it wasn't until the year 2000 that individuals in the UK could actually apply to the European Court of Human Rights in Strasbourg. So this was one of the promises which were made by New Labour, and they actually fulfilled that promise by bringing the Human Rights Act into force on the 1st of October in the year 2000. Now, there was quite a lot of consternation among immigration adjudicators, as they were called then. They're called immigration judges now, who were used to hearing appeals against Home Office decisions, but always in terms of the immigration rules, not in terms of human rights. So, I was an immigration adjudicator myself at that time, and we got a lot of training on how we were to conduct appeals in future. Not all judges were in favour of this new regime. One Lord of Session in Scotland remarked about the Human Rights Act, "It's a nightmare for judges and a gold mine for lawyers." And it certainly led to a big increase in the number of appeals that were going through the system. But since those heady early days, immigration law has become more restrictive. And this is what I'm going to be talking about today. Now, in the first decade of this century, the Home Office practice was when people who were not British had finished a prison sentence, whether it was the complete sentence or being released early on license, well, they would just walk out of prison and go back into the community. And eventually, this was picked up by the press. "What's all this about?" they said. "We've got foreign criminals walking out of jail and roaming our streets, robbing and stealing and mugging and raping. It's disgraceful." And this became quite a scandal. There was a Home Secretary of the Scottish persuasion. I can't quite remember his name, but he commented at the time that the Home Office was not fit for purpose. Something had to be done. And so the government brought in the UK Borders Act in 2007. And one of the things it did was to make deportation the automatic consequence of a term of imprisonment of at least 12 months. Now, prior to that, you could be deported on what were called conducive grounds. If it was conducive to the public good for you to be deported, then the Home Secretary had a discretion to use that power. It wasn't mandatory, it was discretionary. But under this 2007 Act, it became obligatory for the Secretary of State to make a deportation order against any foreign criminal who had committed an offence resulting in a prison sentence of at least 12 months. Now, what about the term foreign criminal? Who would be included in that? Well, it would be everybody, basically, who wasn't British or a citizen of another European member state. It completely blurred the distinction between Commonwealth citizens and aliens, which used to be very important. Commonwealth citizens used to enjoy significant privileges which were denied to foreigners or aliens. So, for example, during the 1950s and the 1960s, there was considerable migration from independent Commonwealth countries to the United Kingdom. It wasn't restricted, and that was not possible for people from other parts of the world. Anyway, that distinction was completely blurred. So you can be a foreign criminal if you're a Commonwealth citizen, and even if you have got indefinite leave to remain in the United Kingdom. So you could have what's also called settled status. You're settled here, and you may have been living here for many years. But that doesn't save you from deportation if you commit an offense and are sentenced to a year or more in prison. Deportation is the automatic consequence, unless that would breach rights under the Refugee Convention or the European Convention of Human Rights. And in fact, what most foreign criminals appeal to, if they are subject to automatic deportation, is their human rights to private or family life, or indeed, very often both. So we've got this quite different procedure now compared with immigration appeals in the old days. No longer are people appealing against the refusal of further leave as a student, leave to remain as a spouse, a work permit, and so forth. The only ground of appeal, or grounds of appeal, are that the decision is contrary to the Refugee Convention or to the Human Rights Convention. You have to bring your appeal on one of those grounds. So when it comes to deportation, nearly always it's the human rights rather than the Refugee Convention which is invoked. And the deportee will be arguing that he has established such strong private or family life ties with the United Kingdom that it would breach Article 8 of the European Convention for him to be deported. Well, I hope that sounds fairly straightforward, but I do beg your pardon. I keep forgetting to do this. Oh, I'd better turn my phone to silent. Sorry about that. It's bad if you do this in court. The judge doesn't like it one bit. Right, that should do it. Where was I? Yes, I was saying it sounds perhaps rather straightforward. You appeal to the Human Rights Convention. Deporting me will breach my rights to private or family life. But this has become hedged about with all sorts of complications. Now, despite what had happened with the 2007 Act and automatic deportation, it was felt that immigration judges, or adjudicators, as they were still called, were still being too lenient. They were invoking the Human Rights Act and allowing appeals on the basis that removal or deportation of these individuals would be disproportionate. Because, of course, the Human Rights Convention involves a balancing exercise between the public interest in maintaining, for example, immigration control and also safeguarding the public against criminality. That's on the public interest side of the balance. And then on the other side of the balance, the individual or family rights. And it's a balancing exercise to see which side of the balance comes down in favor of which side. But the Home Office wanted to tighten that up. And so in 2012, they introduced into the immigration rules a new set of rules which were supposed to incorporate or reflect how the Article 8 balance was to be struck. So for private life, a new set of rules was introduced into the immigration rules, which said that if you had been living in the UK for 20 years, albeit illegally, you could, barring criminality or other serious reasons, expect to be given leave to remain, not indefinite, but leave to remain for 10 years. Or if you hadn't been living here for 20 years, if there were very significant obstacles to your integration in your own country, then again, you might be able to stay on in the UK lawfully. You would be given what was, it was known as the 10-year route. You would be given a route to eventual settlement after 10 years. Okay, that's private life. What about family life? Well, if you were here illegally, you could be granted permission to stay if you had formed a partnership with a British or settled person, and that person, or indeed you as a couple, would face insurmountable obstacles in continuing your family life in the country of the person who was to be removed. Alternatively, if you had a British child or children, or indeed a child who was not British but had lived in the UK for at least 7 years, you could succeed in not being removed if it would not be reasonable to expect the child to leave the United Kingdom. So that was putting into the immigration rules the criteria for allowing appeals on human rights grounds. Now, at the same time, these rules were for people who had simply overstayed or entered the country illegally. They'd committed immigration offenses, but they hadn't committed any other crimes. But for people who had committed ordinary crimes like burglary and murder and so on, they were the ones who would face deportation. And a different set of rules applied to them, stricter rules. But even that was not enough to satisfy the Home Office or indeed the press, because despite judges being steered towards a firmer assessment of the rights of deportees, still many appeals against deportation were being allowed. And back about 10 or 12 years ago, the Daily Telegraph started up a league table in which soft-touch judges were named and shamed, and in particular judges sitting on the upper tribunal. Well, I was sitting there myself at the time, and I'm afraid to say that I very nearly got to the top of the league table. Only one other judge of the upper tribunal was a softer touch than I was when it came to allowing deportation appeals. Now, I should just say in mitigation, although the Home Office was trying to steer judges to take a firm view of offending and to be wary of allowing appeals, in fact, the proper application of the Human Rights Convention makes it quite difficult in certain circumstances to actually dismiss deportation appeals when the result would be very serious consequences for, in fact, innocent members of the family, children. So it's very hard to strike the right balance. Anyway, to bring us a little more up to date, the government in its wisdom thought that the changes introduced in 2012 into the immigration rules were still not giving enough of a steer to immigration judges, because immigration judges were saying, all right, this is what the rules say, but we can also look at what the Human Rights Convention itself says. We can look at the case law of the Strasbourg court. We can apply that to the appeals that come before us. So it's perfectly feasible for an appellant not to succeed under the immigration rules, but to succeed under Article 8 outside the rules. That was happening quite often. So the Home Office introduced guidance directly into primary legislation, and this was the Immigration Act 2014. Certain sections were introduced into the, in fact, into the 2002 Act, but it was introduced by the 2014 Act, setting out how courts and tribunals, so not just the Immigration Tribunal, but the ordinary courts, how they were to assess the human rights of people who were appealing against decisions to remove them because they were overstayers or illegal entrants, or to deport them because of criminal offending. Well, I'm not going to talk about removal for non-criminal activities like overstaying, which it's rather easier to succeed if you're in that category. But I'm going to focus on those who are facing deportation, and the hurdles that they have to overcome are a lot more difficult. Let me just say that around both the immigration rules and these new criteria within the immigration legislation itself, the primary legislation, certain phrases have been the subject of endless judicial interpretation. What do they mean? And it really illustrates how difficult it is for parliamentary draftsmen and indeed the government itself to make its meaning absolutely clear. Quite ordinary language can cause great head scratching when it comes to trying to work out what on earth does this mean. And bringing us really far up to date, what about the way that appeals are conducted? Now, one thing which the government started doing was to actually instigate removal of deportees, physical removal, before their appeals had been heard. Now, everyone who raises human rights as an issue, who says you can't remove me or deport me, you'll breach my human rights, everyone who makes such a claim actually can have an appeal to the tribunal, initially the first tier tribunal, and then possibly to the upper tribunal. But the Home Office thought it would be a good wheeze if they could actually get round this by first of all removing people and only then letting them have their appeals. So appealing out of country. How feasible is that? It started happening a few years ago. The Home Secretary could certify certain claims as justifying removal first. The slogan was deport first, appeal later. Now, this was tried on, and it turned out that there were logistical and legal problems in conducting appeals from abroad. In the early days, technology wasn't terribly good, so a video link between a distant country and a tribunal hearing room was liable to break down. Also, what was the venue to be? It started off that the appellant would have to be at a British embassy or High Commission. And there was a test case a few years ago where the appellant was at the British High Commission in Kingston and the tribunal was sitting at Taylor House in Islington. And they did have a few teething problems. The matter came before the Supreme Court in the end in 2017, and their lordships commented on the difficulties of having actually a fair trial from abroad by video link. More recently, other problems have arisen in that another country might not be happy for live evidence, particularly in a criminal case, to be given from its territory to a court or tribunal in the United Kingdom. And this seems to be a particular problem for the Immigration Tribunal. You might think in these days of Zoom meetings and remote hearings in court that it would, and also the technology has improved so much. Everybody's getting used to Zoom and Microsoft Teams and so forth. You would think that it should be really feasible now for evidence to be heard from abroad. After all, most appeals in the UK nowadays, certainly in the Immigration Tribunal, are conducted remotely. The judge may be at his chambers at the hearing centre. The Home Office presenting officer will probably be in his office or even at home. The witnesses will be at home or maybe in the solicitor's office. The barrister representing them could well be at home. I usually am when I do appeals these days. So everybody's in a different place, and the appeals are still manageable. Why is it that people who are abroad can't join in as well? Sometimes they try to. A while back, I was representing a family. There were 4 of them who were actually living in a Middle Eastern country. And their sponsor in the UK was going to give evidence on their behalf. But at the outset of the hearing, lo and behold, on the screen, there appeared the 4 appellants themselves. And this surprised me. I wasn't expecting that. And it seems that their sponsor had told them that they could join in. Now, the judge was a bit flabbergasted, and in fact, judges have guidance that says that it has to be shown that the authorities in the country where potential witnesses are, and from which they're hoping to give live evidence, that has to be approved by the authorities before they can give that live evidence. And in this case, it hadn't been obtained. There was a fairly recent example of what can go wrong in the case that came before the Court of Appeal, presided over by no less than the Lord Chief Justice. And he was not best pleased to learn that 2 appellants had been removed from the UK to Turkey, they were Turkish, before they were able to appeal against their deportation. So they wanted to appeal from abroad, and it was thought that they would have to do it from the British Embassy in Ankara. Well, it was thought that this could go ahead, but then it turned out that the Turkish authorities wouldn't let that happen. So it meant that there was no way that they could give their evidence from the British Embassy. So what were they to do? The whole thing was very shambolic, and the Lord Chief Justice upbraided the Home Office for not organising something whereby the appeals could be heard from abroad. So perhaps I could just throw in as an aside, it's probably a good thing as far as the Home Secretary is concerned that people who are sent on to Rwanda to claim asylum there will not be able to appeal against the refusal of asylum to the UK, because in fact we will not have been taking the decisions. It will be the Rwandan authorities to whom appeals will have to be made. So there won't be lots of asylum seekers appealing from Rwanda against the refusal of asylum to this country. So anyway, that's appeals from abroad. But what about the bewildering terminology and the attempts to define it? So perhaps I could start off with looking at what has to be proved by a deportee who's relying on his private life in the United Kingdom. That's without any partner or children. So there are 3 criteria that have to be fulfilled. Now, the first of these is that he must have lived for most of his life lawfully in the United Kingdom. And that means more than half. Well, there are a surprising number of deportees who have indeed lived for most of their lives lawfully in the United Kingdom. They could have been brought here as children. They could have acquired indefinite leave to remain and have had it for a long time. But if later in life they commit a serious crime and are sent to prison for at least a year, they are then subject to automatic deportation. And if a deportation order is made, it has the effect of invalidating indefinite leave. So even when you're granted indefinite leave to remain in the United Kingdom, that's no guarantee that you won't be deported. You can be. The only way to avoid that is actually to become a British citizen. Or in some cases, it's open to Commonwealth citizens to have a right of abode. The right of abode is what British citizens have. Even if you become a British citizen, it is possible for you to be deprived of your British citizenship if you represent a serious threat to the national interests of the United Kingdom. So that has happened famously to people like Shamima Begum, who went and joined ISIS in Iraq or Syria, and so embraced jihadism. So they've been deprived of British citizenship, and that would the effect of that would be that they could then be deported if they were in the UK. Although in fact, if they're outside the UK, they can be excluded from coming back, which they couldn't be if they were still British citizens. Okay, so you have to show that you've lived lawfully in the UK for more than half of your life. You must be socially and culturally integrated in the United Kingdom. It's been argued that if you've committed crimes, you might be a persistent offender. You're not socially and culturally integrated. But the general consensus is that if you've come to the United Kingdom at a particularly young age, as a small child, and you've been brought up here, you're what some people call a homegrown criminal. Your parents might have come from, let's say, Nigeria when you were a child, but you've grown up in a part of London where you're completely at home with the local people. You speak with a London accent. You don't speak with the accent of your parents. You're, to all intents and purposes, British. But if you never got British citizenship, and that happens surprisingly often, it's quite easy if you're a child and you have indefinite leave, you can easily get British citizenship. But very often it hasn't been done. And then in later life, the individual is liable to be deported despite having lived here for so long. And then the third criterion which has to be satisfied is whether there would be very significant obstacles to your integration in the country of your nationality to which you're going to be sent. Now, that actually is also a criterion which has to be fulfilled by overstayers or illegal entrants who are appealing against what's called simply removal to their own country. And it's almost always invoked, in my experience, by people who've, and there are a surprising number, people who come here on a visit visa and simply overstay. And years later, they apply for leave to remain, permission to stay in the UK on human rights grounds, on the basis of their long residence in the UK. They formed strong ties, friends, and community in the UK, but also they would face very significant obstacles in their own country. Why? Well, because they've lost all ties with their own country. They've not been in touch with their family or their friends for donkey's years. So if they go back now, nobody will come to their aid. They won't have anywhere to stay. They won't be able to get a job. They will be destitute. The Home Office takes this with a pinch of salt and suggests to the appellants, when they come before the tribunal, that it's most unlikely that they would have completely lost all ties with their families back home, or indeed that friends and relations in this country would be unwilling to send them a bit of money to help them get on their feet back when they're back in their own country. But anyway, that's the argument that many will use on appeal, that there would be very significant obstacles to integration in their own country simply because they would be unable to make a living and they would be destitute. Well, similar arguments will be used by deportees who are relying on their private lives. And actually, unlike the overstayers who came with a visit visa and simply stayed on after that, many of these will be people who came to this country at a very young age, and they were far too young to have any part in the decision to come here, and they may well have come legally in the first place. So they've come at a very early age, and they're now being told that they're going to be deported to a country where they've never lived since they were a tiny child. And they might have heard a lot about the country from their parents, but they won't have had much experience, if any, of actually living there. And it may well be very difficult for them to adjust to life in that different culture. They may not even speak the language. I've come across a surprising number of migrants who have not really bothered to make sure that their children speak the native language. And so the children are really not very good at communicating in their parents' native language. They might understand it reasonably well. They might not be able to speak it at all well. So that can happen in a surprising number of cases. Now, what about family life? Now, there's rather a narrow definition of family life for the purposes of arguing human rights. It's really only the relations between spouses and partners, or between parents and minor children, which automatically are considered to be family life. It's quite hard to argue that family life subsists between a parent and adult children. The adult children are supposed to be independent. Not so much these days. There are plenty of adult children living with their parents these days, but unless there's some unusual degree of dependency between the parents and the adult children, that will not count as family life for the purposes of Article 8. So let's look then at the relationship between partners and between parents and children. Now, in the primary legislation, and indeed in the immigration rules as well, it's a bit confusing that we have both. But anyway, the criterion there would be that the deportation of the appellant would have an unduly harsh effect upon the partner or the children, or both, either because they would be accompanying the deportee to his own country, and it would be unduly harsh for them to live there, or because they would be staying behind in the UK without the deportee. They would be deprived of a husband or a father, and the effect of that would be unduly harsh upon them. Now, what does unduly harsh mean? What is unduly? That has caused a great deal of head scratching, and I'm just going to cite some case law on that. Now, an early definition, if I can just find it, came from Lord Carnwath, sitting in the Supreme Court in 218. And unduly harsh, he said, imports a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. Now, that definition provoked some subsequent interpretation by the Court of Appeal. So, for example, in a well-known case called H.A. Iraq, Lord Justice Underhill, who is the Vice President of the Civil Division of the Court of Appeal, said that this explanation could not be read entirely literally, since it was difficult to see how one would define the level of harshness that would necessarily be suffered by any child. So a different definition was proposed, but different judges have made different attempts to put a gloss upon what Lord Carnwath said. Just to repeat, unduly harsh means imposing a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. So one judge said, for some children, the deportation of a largely absent parent may be a matter of little or no real significance. For others, the deportation of a close caregiver parent, whose face-to-face contact cannot continue, may be akin to a bereavement. Another judge spoke of an enhanced degree of harshness, sufficient to outweigh the public interest in the deportation of foreign criminals in the medium offender category. Oh, what's a medium offender? That is someone who has been sentenced to at least 1 year in prison, but under 4 years. If you get 4 years or more, you can only succeed on appeal in very compelling circumstances. So the exceptions I was talking about concerning unduly harsh, excuse me, and very significant obstacles, you have to go beyond that if you've been sentenced to 4 years or more. There have to be very compelling circumstances. But anyway, going back to what unduly means, we see elsewhere the criterion of undue harshness sets a bar which is elevated and carries a much stronger emphasis than mere undesirability. Furthermore, the hurdle representing the unacceptable impact on a partner or child should be set somewhere between the low level, applying in the case of persons who were liable to ordinary immigration removal, that's the overstayers and illegal entrants, and the very high level applying to serious offenders, the ones who've been sentenced to at least 4 years in jail. And then it's also been remarked, there is no reason in principle why cases of undue harshness may not occur quite commonly. It is not possible to identify a baseline of ordinariness. Now, what does the ordinary immigration judge do faced with all these definitions? Because of course, the initial appeal against deportation comes to the first-tier tribunal, and it's first-tier judges who have to decide whether to allow or dismiss the appeal. Now, the Home Office will invariably appeal when a first-tier judge allows a deportation appeal. And usually they will argue that the judge did not give sufficient weight to the public interest in deportation. The public interest being to safeguard the public against criminality and also to deter others who might be minded to indulge in criminality, and indeed to express public revulsion at this kind of behavior. Well, in practice, it's very much harder to succeed purely on private life. I think in general, you would have to have come to the UK at a very young age, and so have lived nearly all your life in the UK to be able to argue successfully that you couldn't integrate in the country to which the Home Office proposes to send you. You've got a much better chance if you have family life with a British spouse or partner and you have British children. In fact, if a child has already had several years schooling in the UK, then for the child to be uprooted, the effect would be more serious on a child who's been at school for a few years, has made friends outside the family home, and has become more integrated within, the outside world, rather than a very small child whose life really revolves around the parents and the home. So you stand a much better chance of showing that the effect on those older children would be unduly harsh. Well, what does the future hold for deportation? It seems to me that as long as the Human Rights Convention remains in force in the United Kingdom, in the sense that it can be used by individuals when they go to court, they can appeal to the Human Rights Convention. And so the case law of the Strasbourg court is still relevant to the interpretation of how we deal with deportation appeals. It may be that Britain is going to withdraw the right of appeal directly to the Strasbourg court and remove the direct effect of the European Convention by substituting a British Bill of Rights. Now, that is proposed. It was proposed before by David Cameron, but nothing came of it. Maybe it will indeed be introduced into Parliament during the current Parliament, while the Conservatives enjoy a large majority, it may well be introduced. And that will no doubt restrict further the ability of foreign criminals to get to stay in the United Kingdom when the Home Office really wants to remove them. But just a final comment from me. I'm constantly surprised when I get instructed for appeals, whether it's deportation or removal, to see what's called the immigration history. The Home Office will prepare a bundle, and that will include the reasons why they want to remove or deport the person, but also it will list the various contacts which the Home Office have had with the appellant over the years. And very often you'll see that various attempts have been made in the past by the appellant. There may have been 2, 3, 4 applications for leave to remain. Each one refused. They may have appealed, lost their appeal. They may have tried again, another application. That application's refused. There might be a right of appeal, there might not be. This might have been going on for years, and they're still here. In fact, the removal rate is very low compared to the number of people who could be removed. So an astonishingly small number of people get removed every year. And I wonder if that is ever going to change. The trouble is, if you're here without permission, without leave to remain, your ability to get work is restricted. Basically, you can only work in the black economy. Employers risk a hefty fine if they employ people who don't have the right to work here. So those who do manage to get work are getting paid cash in hand, not very much, and living very much hand to mouth, unless they have friends or relatives who will help them out. And I think there are a very great number of people in that situation. Many of them are hoping that there will be an amnesty in the end. And there was a rumor going round a while back that Boris had said in the past, when he was mayor of London, that he favored an amnesty for people who'd been living here for 12 or 10 years, whatever, at least 10, and that they could regularize their status and start paying taxes and so on. But nothing has come of it. A rumor went round, even some crooked representatives were taking money off people, saying that they could wangle them leave to remain under the amnesty. And of course, there was no amnesty, but crooks were taking money off people who were living here illegally, promising them that they would get leave to remain. Anyway, I think that's probably quite enough from me. I'd better check the chat box and see if there's any questions. So do excuse me while I take a look at that. Oh, and questions and answers. Oh, right. Somebody has mentioned a case called Araba, evidence from abroad, Nair guidance. That's the upper tribunal explaining how you go about getting permission from the authorities of a foreign country for evidence to be given live by video link from that country. You have to go through the Foreign Office, or as it's now called, the Foreign Commonwealth and Development Office, and they have a unit who handle such requests. The Home Secretary who said, the Home Office is nae fit for purpose. That was John Reid. So thank you for that. And let me now turn to questions and answers. Do you think the Immigration Act 2014 and the 2012 rules constrained tribunals' ability to render Article 8 compliant decisions, so much so that the independence of the judiciary is at risk. No, I don't think that. I think the judges very much value their independence, and they, of course, they have to enforce the law as it is, but there is quite a lot of leeway, even in what looks like restrictions upon Article 8, because you have to make, it's called an evaluative exercise when you're deciding on whether something would be unduly harsh. You have to evaluate in the individual circumstances. You can't really apply the same criteria to every case. It will vary from case to case. So I think that's how we get around it. And could you talk a bit about how the NABB, the Nationality and Borders Bill, will affect these rights? Well, everybody knows about the plans for refugees. I think appeal rights within the United Kingdom itself are not going to be affected. So I don't really think I can talk about that right now. Let's see about any more questions. Oh, I think that's it really. So are there any more questions for me? Because I think...
Yes, Richard,
yes.
Can I ask you what your view is of the proposal to send asylum seekers to Rwanda?
Well, it could be asked, what's the alternative? Because it seems impossible to stop migrants getting here. They will keep coming. So what do we do? Now, because the removal rate is very low indeed, most of the people who come here, whether it's in dinghies or on the back of a lorry, will end up staying here. Whether or not they're actually granted asylum, they're here. They're going to stay. So what can the Home Secretary do? Now, Rwanda seems like a very shocking choice of destination, because most people have seen Hotel Rwanda and know about the genocide and think that it's still like that. In fact, as far as the economy goes, it's the fastest growing economy in Africa. Kigali is a very modern city, very clean. There's no rubbish. I mean, London is much dirtier than Kigali, and you can get work in Rwanda. But should we be sending people to another country to claim asylum there? And if they fail to get asylum, it's that country that has to decide what to do with them. It probably won't survive. I don't think it's going to work. I mean, the common opinion, I think, among immigration lawyers and indeed judges is that it's simply not going to work. And that the number of people who are actually removed to Rwanda will be very small. It's not going to be tens of thousands. It might be a few dozen or a few hundred at the most before the whole thing is shown not to be working. But it's not so horrific as people might think. You know, you're going to be sent to Rwanda and you're going to be tortured, you know, or killed or something. It's not going to be like that.
Right. Thank you very much. I don't think there are any more questions. The webinar started without an introduction because you started straight away, but in a sense, you need no introduction. Those delegates who are here, if they're immigration practitioners, will have heard of and perhaps even appeared before Richard McKee, barrister and now retired immigration judge. Can I thank you very much for a very informative talk?
Thank you very much, Barbara. It's been my pleasure. And fortunately, I wasn't coughing too much, so the absence of a mask really didn't make any difference. And thank you all for attending. I actually can't stay for the rest of the webinars because I've actually got to teach a class of law students at 7
Okay.
o'clock, but that will also be a webinar. I don't have to go far. So thank you all very much.
Thank you very much.
Good evening.
Right, well, to the participants who are still with us, our next webinar will start in about 10 minutes time. So you've got a 10-minute break. But I ought to say that the speaker, Melissa, is unable to be with us, but she has sent her talk and she has asked me to read it out with the slides. And so I'm going to do that in about 10 minutes time. If I appear to be lisping, we're having rather a bad day with Richard's cold and my lisping, that's because I've just come from the dentist. So I'm sorry about that, but I hope to be able to speak more and more clearly as the anaesthetic wears off. So can we resume again at 6:40, please? That's in about 7 minutes time for Melissa's talk, which I shall read to you about regulating the robots. A very interesting talk. Thank you. As I said before the break, the next webinar is on regulating artificial intelligence. It's written by and should have been delivered by Melissa Coutinho, written it and has asked me to read it out to you. So that's what I'm going to do. It's accompanied by slides, and I hope to be able to show those slides. So what she says is this. She asks you, first of all the delegates, to consider if you use an iPhone, iPad, predictive text on your phone, Google Maps, Citymapper, SatNav, whether you use a search engine when researching something on a computer, whether you allow iTunes to recommend playlists to you, whether you use social media. If there's anyone who hasn't indicated an affirmative answer, then she would ask you to say so through the chat bar, but she's not here. But she says that she would be surprised to identify anybody who falls into that category of not using any of those devices. She anticipates that most, if not all, could say that technology is something that they used. And so she wants to bring home to us all that artificial intelligence is already part of our everyday lives without having to imagine a different future. I'm going to share a screen with you now so I can show the slides. She goes on to say that there are automated receptionists, health educators, caregivers taking increasingly humanized forms, but we all are already used to robotic items because they're used in complex surgery, in warehouse retrieval, floor cleaning. Those are just some of the tasks that robotic items can do rather than people, without needing to factor in human tiredness and consequent error. The capability of robots has been embraced. Of course, there are other sorts of mistakes or errors that can be made that also need to be considered. What the lecture is going to cover is, first of all, the rationale that needs consideration before legislation is created, and secondly, what the purpose is of the legislator, and finally, the impact of regulation. And she says she's going to cover that because some of us as lawyers will look at it in considering a regulatory framework for products. Sorry, I'm trying to take up the whole screen, but I'm struggling to do that. And she goes on to say that it's something that we need to consider. And she's going to consider how we tackle regulation in terms of robots and wider artificial intelligence. She's also setting out what she's going to tell us so that we can work out that there are 3 areas that really need to be covered, and that's what she's going to do in this lecture. The first area is rationale. At present, there isn't an act or regulation in the UK or the European Union that deals with all aspects of robotics or artificial intelligence. And to date, this has perhaps been because they've been treated as objects, and their virtual manifestations as an oddity that is peculiar to that genre. What she wants to say is that for robots, there's no reason why their physical structure should not comply with any other physical safeguard covered in product safety legislation in the absence of more specific sector applicable legislation. The materials that they are made out of, their component parts, the hardware that enables them to undertake human or superhuman activities, can all come under legislation. However, the artificial intelligence that brings life to the most sophisticated robots is an area that lawmakers have already begun to have concerns about, and it's that needs to be addressed. To understand the challenges imposed by artificial intelligence, or AI, to use its common abbreviated form, it's necessary to comprehend what AI constitutes. AI is intelligence shown by machines, in contrast to what we refer to as the natural intelligence displayed by humans. Although, given that we encompass a spectrum also, we might not all agree with that. Where an environment and experience can be taken into account by a machine in order to take actions which maximize its chances of successfully achieving its goals, AI is considered to be demonstrated. Colloquially, the term AI is often used to describe machines or computers that mimic cognitive functions that humans associate with the human mind, such as learning or problem solving. Examples of AI involve identifying the best match of a cancer treatment when evaluating the genetic components of an individual by being able to consider thousands of patient profiles, looking at what has been successful for whom. And she directs us to slide number 4. In the current pandemic, small pockets of knowledge are being used to model what the spread and peak of infection, allowing decisions to be made without balancing restrictions with beneficial effects for the right cost-benefit outcome. What this means is that AI can be designed to work faster and more efficiently than humans. In fact, a key component of the ability of AI to learn and outstrip the knowledge of its creator is one of the important features, but it's also one that causes greatest ethical and legal challenges, the regulation of something or a consequence that does not yet exist. Normally in product safety, a manufacturer must make a safe product. Safety will be linked to the materials used, the technology known, and how the product is to be used. There may be particular standards associated with different materials or components if particularly specialized, but there is the recognition that many products will present dangers if misused. Some are more obvious than others, and some more likely to be protected against than others. What about robots and AI, though? What about artificial intelligence or robots making a decision that its human creator would not make? There appears to be no reason why the risk of foreseeable harm should still not be applied. And this is true of the product as it is true of the consequence that could result. For example, stepping away from AI for a moment, many cars have the capacity to go faster than the legal limits permitted on public roads in the UK. However, if cars are driven faster than they were meant to be continually, particularly in built-up areas, this could damage the car, or cause damage to property, or cause injury to people. Is that a reason to limit the capability of the vehicle? It's not the law in the UK for that safety requirement. Similarly, if data protection is not considered in devising software, the data it accesses may not be secure. Data breaches may result in the event of deliberate or accidental hacking. The question is this still something that its inventor needs to be held responsible for? Because he or she knows that the ability of something they've created is capable of outstripping their own abilities. Should it be the programmers or the owners who hold responsibility? Or is this a situation akin to children and animals, where an adult and or owner must in certain situations take responsibility for the child or the animal? In which case, is there an equivalent case, such as there is for children, needed, a comparator to an age of legal accountability, with consciousness at a certain level triggering responsibility? or even if it is more practical, that there should be, as there are with dangerous dogs, legislation that governs them in terms of what is socially acceptable? Are we looking at creating a legislative framework that can be applied to provide some accountability, even if that will still have to apply to a legal person, which takes us back to the question of who that person should be? She goes on, slide 7, sorry, I missed one, there we are. The world is changing. Recently, in October 2017, the android Sophia was granted honorary citizenship in Saudi Arabia. Some observers found this to be more of a publicity stunt than a meaningful legal recognition. Interestingly enough, Sophia was not determined to be female, meaning that the rights she had may have exceeded some held by natural persons. Some saw this gesture as openly denigrating of human rights and the rule of law. Surprising as that sounds, should it? There is recognition of legal persons who are not humans, be these companies, sovereign states, organizations, trade unions. And if companies can hold money, they can also be fined. So one option might be to give rights to robots and artificial intelligence simply because of their capabilities and what they might achieve. It's easy to think of the legal world in terms of human rights. However, we live in a world where humans are not the only ones that have rights. In the eyes of the law, artificial entities have a legal persona too. Corporations, partnerships, or nation states also have rights and responsibilities. With rapidly evolving technologies, should the law recognize that AI and robots have these rights as well? If you have a view, Melissa said she would be interested to know. In fact, I think that Ceba is suggesting this at some later date because I can't answer questions on her behalf. Those of you who do have views or comments or questions might be given an opportunity through a face-to-face session to attend Ceba when Melissa is able to attend and take your comments and views. So she goes on to say that if Facebook or Google or Amazon's Alexa qualify for a new status in law with new responsibilities and rights too, would this be a positive move? Or is it simply passing the buck so that the creators and owners of technology escape their liabilities? Has sufficient thought been given to how artificial behaviors need to be controlled? Most problematically, of course, is that few of these behaviors come out of nowhere, but sometimes, like animals and children who are also capable of learning, reflect the prejudices and views of their creators or those they come into contact with. So, sadly, in some instances, the nature versus nurture debate is not answered positively, and this is something that legislators need to consider. Slide 8, which I think actually is slide 6, Melissa asks, who is this? She is Tay Tweets. She was a chatbot created to interact with other teenagers and evaluate their tweets, learning from them. Instead, she became sexist and racist and had to be closed down after only 16 hours of existence. Why? Because she learnt from the number and type of similar entries made available electronically, and numbers counted for more than evaluation of their content. And that's why she turned out to be, as she was, sexist and racist. What she learned was not what was anticipated. And this might beg the question that AI used in job selection might also learn bias, so that learning about successful outcomes for job applicants might lead an artificial selector to conclude that a certain type of person does better, and in so doing perpetuates myths about gender or race. Perhaps considerations that it was hoped the machine would be more obviously blind to when other parameters are equal. The same argument may hold true when considering the possibility of algorithms that evaluate legal claims or initial judgments being made by electronic legal judge or assessor. Could a computer be relied on to be fair simply because they've been programmed in a certain way? And she asks rhetorically, because she's not here, who would trust somebody with their legal claim or case, and who would prefer a jury of robots rather than their peers to determine their case? Would that depend on who programmed the robots? If we do any of these lectures subsequently, perhaps face-to-face, Melissa said that she would be very happy to receive feedback on it. And she makes the point that one can't ignore what goes into creating the artificial intelligence item or robot, because that might be an obvious place for regulation to bite rather than awaiting its outcomes. Secondly, she moves on to the purpose of the legislator. The ethics of artificial intelligence is part of the ethics of technology specific to robots and other artificially intelligent beings. It's typically divided into robo-ethics, a concern with the moral behavior of humans as they design, construct, use, and treat artificially intelligent beings, and machine ethics, which is concerned with the moral behavior of artificial moral agents. What a legislature and society should want is threefold. Clarity. Sorry, her slides seem to have got out of sequence. We're on slide 8. Clarity. You can't see the slides, somebody says. Let me see whether I can upload them again. Okay. Hopefully you can see the slides now. Yes, good. This is what is needed: human agency and oversight, technical robustness and safety, because AI systems need to be resilient and secure. They need to be safe. Transparency: the data, system and AI business models should be transparent. Traceability mechanisms can help achieving that. And in addition, the systems and their decisions should be explained in a manner adapted to the stakeholder concerned. Humans need to be aware that they are interacting with an AI system and must be informed of the system's capabilities and limitations. There needs to be diversity, non-discrimination and fairness. Unfair bias must be avoided, as it could have multiple negative implications, and she's already given some examples, from marginalization of vulnerable groups to the exacerbation of prejudice and discrimination. Fostering diversity, AI systems should be accessible to all, regardless of any disability, and involve relevant stakeholders throughout their entire life cycle. And then societal and environmental well-being. AI systems should benefit all human beings, including future generations, and it must be ensured that they are sustainable and environmentally friendly. Moreover, they should take into account the environment, including other living beings. Their social and societal impact should be carefully considered. And then finally, accountability. These mechanisms should be put in place to ensure responsibility and accountability for AI systems and their outcomes. Auditability, which enables the assessment of algorithms, data, and design processes, plays a key role in this, especially in critical applications. Moreover, adequate and accessible redress should be ensured. Without these safeguards, she says that there are a number of possible consequences, including stifling of innovation, abusing AI and the consequent mistrust of artificial intelligence. Stifling of innovation can also lead to lack of progress. Abuse of AI can lead to hacking, chatbots, and influencing the vulnerable, and the consequent mistrust of AI, going back, for example, to using physical maps. All of those consequences encompass everyday issues to the sensational implications. So greater clarity, legal clarity, will need to be resolved in order to address those consequences. But given disputes between different AI lawyers on a meaningful definition, more sophisticated thoughts may need to be given to the types of AI and robots, their capacity for learning, both in terms of speed and sophistication, and how much detail there needs to be provided by the legislation if the law is not always to be behind the products that are created. She says that she asked about examples of technology assisting humans by using AI, whether it's parking sensors and monitors in your car, fingertip recognition for your electronic device, Fitbits or other activity tracking monitors. No doubt we've all got a view on whether these constitute reliable and good AI or not. And then she says to consider environmental questions. We move on to slide number 10 for that. She asks, which do you think would be safer, the airplane or the car? You're looking at both here. Which is more commonplace? Which has the greater proportion of accidents? Which are you more likely to survive? Think about long-haul air travel and a fully automated car. Is human error or machine error more likely? Is machine error largely the result of human oversight? How do we know that this has been adequately addressed? In fact, air travel is safer than car travel in terms of numbers on a mathematical percentage basis of mean averages. But when it comes to regulation, it's not simply thinking about modern technology, but about careful analysis of public reaction and dividing up areas that need not be elided. An example of this from history would be the move from horse-driven carriage to the so-called horseless carriage or motor vehicle. When this move came about, there was concern that was quickly addressed. The problem with the technical issue, i.e. a fault with the car which the manufacturer is responsible for, is distinct from the fault of a driver who doesn't follow the laws for road use. The law is able to distinguish these and to ensure that there are different routes for resolution. If this is possible without complex mental gymnastics, shouldn't it be possible to similarly achieve this with robots and artificial intelligence, without, of course, minimizing the fact that the degree of sophistication needs to be greater? To be worthy of people's trust, greater clarity around the status of AI will certainly be important. And this isn't just about justice for robots, it's about justice for society at large. She moves on to slide 12, which she calls Jessica Rabbit. I'm not bad, I'm just drawn that way. Just because a machine can learn, do we absolve the creator of the capability that the creator gives to that machine? As legislators, do we want to provide reassurance and certainty for users and society that regulation applies and problems can be resolved? After all, one of the biggest and legally disruptive challenges posed by AI is what to do with machines that act in ways that are increasingly autonomous. This needs to be separated from their deliberate misuse, which should also be addressed, but in a different way, which is separate again from the potential for negative and unintended consequences that they may be responsible for, which nonetheless feeds into any risk-based equation. She says that this slide is a slide of drones at an airport, what could have been done and what has been done subsequently. Is this about recording purchases, as is done with mobile telephones, limiting the availability of what is commercially available to routine consumers, as is done with some medicines, or ensuring tracking is in place to identify their use, as can be done with any electronic good containing a computer, ensuring that an override button exists to prevent misuse as occurs in planes. So those are some ideas that she puts out to you for thoughts for legislation. which brings her on to the third part of her talk, which is to deal with the impact of legislation. How do we classify robots and artificial intelligence that will have enormous significance in terms of regulation? Once upon a time, the law was clear, Melissa says. A manufacturer was held responsible for the thing that he or she made. How it was used was secondary to that, because it wasn't considered fair to hold responsible a manufacturer for the misuse of their product for a purpose other than that for which it was intended by them. So if knives were being taken out of the kitchen and used by gangs, that could not be said to be the manufacturer's fault. Or if glue was sniffed rather than used as an adhesive, or if over-the-counter paracetamol was used for a deliberate overdose rather than to treat a headache. What happened in these instances was that necessary safeguards were applied. However, the law has changed. What is known about how a product is actually used can be relevant in terms of its classification and regulation. Accordingly, in two recent High Court cases, decisions were made about the use of a product and how that influences classification and therefore the regulatory regime that applied. With an appeal from the criminal courts, a decision was made about nitrous oxide, laughing gas, hippie crack, N20, sweet air, actually I think it's this slide rather than the other, were their street names. It can be a drug that is abused, or it can be a medicine, or part of a manufacturing process, creating everyday products such as fizzy, frothy drinks. Its context is all important and changes how it is classified in law. You can imagine that investigators and regulators want to know about how its manufacture, packaging, where it's sold, and to whom. These indicators are used as evidence of lawful, regulated, or illegal activity. While there are responsibilities on the manufacturers concerning production and presentation, up until 2018, there was a position that was held by many regulators, which in effect said that providing products were manufactured lawfully, if they were misused, this was not an issue for the manufacturer, because one can regulate a process and an intention of the manufacturer or marketer, but not possible misuse for purposes engaged in by the consumer that were not so intended by those who placed it on the market. The thinking behind this was that if people choose to misuse everyday goods, such as glue or knives, that's not the manufacturer's fault any more than a company making chocolates can be blamed for the overconsumption by the population at large. However, and whilst it's an aside, consider the restrictions on the advertising of alcohol and tobacco and how this looks set to grow, where additional accountability and freedoms to market will increasingly be balanced with the necessary protections needed for our safety and the proportionate use of finite resources. Since the case of Blue Bio, it is not enough for a manufacturer to make a product as a food supplement if they know that the product is going to be misused as a medicine. This means they have an obligation to monitor the use of their product and respond to that. In the case of Blue Bio, this meant that being clear what was on social media sites, whether doctors were prescribing their products or pharmacists dispensing them, was important. If they were being used as a medicine by a significant proportion of the consumer base, although what was significant was not specified, this needed to be taken into account and the appropriate license obtained. Expanding on this thinking, what features of AI might a regulator need to take into account to consider comprehensive coverage? Well, says Melissa, here are some examples. Slide 11, I think it's slide 15, a picture of three girls. She asks, who of you in the audience recognizes these images? What do you think they've got in common? Well, associated with them are allegations of poor behavior in relation to algorithm use. For Molly, who took her own life, there was concern from her parents that images on Facebook contributed to her death. This, in part, was because of an algorithm which operated to mean that people looking at some types of image may be fed more of that type of image and related images, with matters progressing. It's a reason why once you look up one item, if you're not careful, that your YouTube feed or your Pinterest continue to bombard you with information or pictures you may or may not want to see, unless you specifically disable the function. There's no specific requirement not to use algorithms in this way, and there is some dispute over what images will recognize as they learn. It's also why your phone or apps can listen into conversations if these are functions that you haven't disabled on your mobile phone or your tablet. What Facebook has said is, quote, "This is a voluntary position at present. While those who are vulnerable need to be protected, this is also about legitimate business practice and freedom of expression. What becomes a tightrope concerns human rights, never mind machine ones. Regulation comes into force, especially if the general public is to trust AI's meteoric rise and use by technologists. Those who say that regulation will not work and will have no impact are in the minority. Most regulators consider that a legal framework is critical, particularly because of the pervasiveness of AI and the fact that it's not tied to a single type of product or profession where existing frameworks exist, and there are regulatory penalties, including being prevented from working in a particular profession if they break an ethical code. It's the case that if an algorithm makes an autonomous decision, it's not clear what person, if any, is held responsible. Rather than simply accept this, a framework could be created. Those with expert knowledge and experience have come together in the EU high-level expert group on AI to share what we think are the best ideas and discount those that will not assist with core issues. Experts agree that a clear chain of human accountability is crucial, and the EU's new General Data Protection Regulation already helps in that regard. But now and in the future, new laws will need to do more. As problems have come to light, so have others, such as pacemakers being hacked, meaning not just personal data that needs protection, but the consequences of anti-hacking software being included in medical devices can be all important. Or even something which seems like a good idea, but has not considered the ethical implications, such as intelligent pills. She says slide 20, but slide 20 goes on to what she's going to come on to in a moment. So she says there's something that seems like a good idea, but hasn't been considered, is ethical implications. Ingenious, a tiny sensor could be inserted until it reaches, to take an analogy with pills, stomach acids. Magnesium and copper, which generate power through chemical reaction, could communicate a unique signal to the patch or the chip. The chip could be implanted and worn as a patch, storing information, and that information could be forwarded using Bluetooth technology. It could be received by a smartphone with access to a doctor or patient or patient's relatives or carers. All right, I think this aspect of Melissa's talk smacks of something from tomorrow's world. Sadly, she's not here to take what I suspect would have been very many questions on that topic. She goes on to say that fearmongers decry the rise in AI, but really they are too late. The technology revolution has already occurred. Do we want to do mundane jobs, or do we want AI and robots to do those mundane jobs? And most of us would say yes to the artificial intelligence item doing it. Looking back 20 years, you would have been searching through bank records and mobile telephone numbers by looking at paper records. Facial mapping software didn't exist. Police looked through hundreds of photographs in turn to find particular items. Finding an individual took more than a combination of 1 or 2 electronic searches. 2 months ago, Labour mooted the idea of bringing in a 4-day week. Some thought that that was unrealistic. And after all, how would that work with the courts? Others saw that it was a way of dealing with a growing population. But just maybe it isn't so far-fetched after all, because if more of the mundane is done by machines more efficiently, doesn't that mean more of our valuable time gets to be spent on the things that AI cannot do as well, such as being creative, novel, using the law in a human way? She asks whether you're convinced by that. It's not her place to persuade you, but she invites you to read Professor Susskind on what AI could mean for our work and life in another 20 years. For those who feel a fear or think that a simple solution is the answer, she says that the EU group did consider science fiction as an inspiration. Asimov's laws, and these are what are now on this slide, usually entailed 3 guidelines for machines. Law 1, a robot may not injure a human being or through inaction allow a human being to come to harm. Law 2, a robot must obey orders given to it by human beings, except where such orders would conflict with the first law. And Law 3, a robot must protect its own existence as long as such protection does not conflict with the first or second law. Asimov later added the Zeroth law above all the others. A robot may not harm humanity or by inaction allow humanity to come to harm. Well, some of those problems that occur in fiction, Melissa says, also occur in real life. In Asimov's fiction, humans are given a certain definition. In the real world, whilst there is an accepted definition, genocides still occur. The suggestion that some people are regarded as more human than others who are expendable. Further, the most important reason for Asimov's laws not being applied yet is how robots are being used in our real world. You couldn't arm a Reaper drone with a Hellfire missile or put a machine gun on a Mars, that's a modular advanced armed robotic system, not to cause humans to come to harm. That's the very point. And if the good chaps can carry out this programming, so can the baddies. And finally, the fact that robots can be sent out on dangerous missions to be eliminated is often the very rationale to using them. To give them a sense of existence and survival instinct would go against that rationale, as well as opening up potential scenarios from science fiction where they become more interested in their own survival over mankind and go rogue. Melissa stresses the importance of ethics. The real issue for robots and AI, she says, comes down to ethics. This is not just about whether we can use something like Asimov's laws to make machines as immoral, which may be an inherent contradiction, given that morality wraps together both intent and action, not mere programming. Rather, we need to start wrestling with the ethics of the people behind the machines. Can ethics be regulated for? Well, while social norms of what is acceptable change, whether this guides what people understand to be right and doing no harm, or whether the law changes undesirable behavior, is as much a sociological question as a philosophical one. Where is the code of ethics in the robotics field for what gets built and what doesn't? Who should be able to write a code to power robots and develop AI? Should these sophisticated systems be limited to people with special training or licenses? Well, that boat has already sailed, but just perhaps some of these issues need to be revisited, not with a view to stifling innovation, but in order to manage the risks. We would be naive to ignore them. So perhaps it matters less that legislation isn't fully in place now, but it is likely to get ever more important. And then she concludes her talk by summarizing what it is that we have learned that needs to be considered. The rationale that needs consideration before legislation is created is the first thing. Secondly, the need to be clear about the purpose of the legislation. And thirdly, the forecast of the impact of regulation, which sometimes means that laws need to be revisited. And she says she has a final slide, which is here. Slide 23. Most people are unaware that at the present time, an individual who has no legal training or qualification can set up a company or business offering to sell legal advice and documents to the general public on a wide range of legal matters and without being subject to any sort of regulation or standards monitoring or financial control. Whilst there are presently some types of legal work which can legally only be carried out by qualified solicitors, for example, representing clients in courts, making probate applications, there are also a number of areas where unregulated legal businesses can legitimately operate. One particular area where this is true is writing of wills and associated services, such as the provision of powers of attorney. There's no legal framework in place to regulate or control legal services businesses or the individuals who run them, or to monitor the quality and accuracy of the work that they produce. And this is a matter of some concern to those who are legally qualified and who are bound by strict regulations and financial controls. And given that so much of that work is by its nature work that is carried out on behalf of elderly or otherwise vulnerable people, that might be another area that needs to be visited in a future lecture. Similarly, in the case in the field of medicine, not all medicines are regulated. Herbal medicines, many herbal medicines are not regulated. Remedies specifically prepared for individuals don't need a license. Those manufactured outside the UK may not be subject to regulation. So this also provides examples of laws where there may need to be some changes brought into place. And so with robots, they need to be assessed and perhaps assessed every 5 years to assess their capability. There are fewer surprises then, and hopefully more openness. Deep Blue was a chess-playing computer developed by IBM. It was known for being the first computer chess-playing system to win both a chess game and a chess match against the reigning world champion under regular time controls. Deep Blue won its first game against the world champion on the 10th of February 1996 when it defeated Garry Kasparov in game 1 of a 6-game match. However, Kasparov won 3 and drew 2 of the following 5 games, defeating Deep Blue by a score of 4-2. Deep Blue was then heavily upgraded and played Kasparov again in May 1997. Deep Blue won game 6, thereby winning the 6-game rematch, 3.5 to 2.5, and becoming the first computer system to defeat a reigning world champion in a match under standard chess tournament time controls. Kasparov accused IBM of cheating and demanded a rematch, but IBM refused and dismantled Deep Blue. We would just have to hope that the assessment can be done without the cheating that humans employ when they are assessed. Whatever the solution, it's likely that some of you will be able to contribute to it. Melissa says that she sits on several groups considering AI, and she's adamant that each generation adds something new as behaviors and the understanding of capabilities and what is commonplace emerges. This is definitely one area where we can all benefit from each other's experience with traditional lawmakers, engaging with those creating and using new technologies. She hopes that you have enjoyed the lecture, and I hope you've been able to follow it all. It was certainly a very interesting paper, and she hopes also that you learned something from it. She says she's happy to answer questions. As I say, you can't at the moment because she's making her way from Scotland, where she had her accident. But Ceba hope, and you need to keep an eye on the website, Ceba hope that there will be a future opportunity for you to take part in a face-to-face session with Melissa contributing and answering questions. So I'm sorry that you can't contribute to this. I'm going to stop sharing and hope that we come back to the full screen. Thank you very much for, seem to have appeared twice somehow, for attending this session. The next session doesn't start until 7:50 because we've lost the question session that we would have engaged in. So can I ask you to have a break, have a cup of tea, have some biscuits, and come back at 7:50 for another very topical discussion by Araba Taylor on heritage items at 7:50. I make it 7:31 at this time. All right, thank you very much. Also, a Deputy District Judge and Deputy Chancellor, very topical for the subject that she's going to deal with today, which is contested heritage, an issue that has come up in many different forums, from criminal, Bristol case, to ecclesiastical, the Rustat case. And so Araba Taylor is going to give us a talk about contested heritage, law, religion, and the slave trade.
To start with. Okay, so good evening everybody, and thank you so much for coming to the webinar. I hope it's been interesting so far, and I hope this talk will also be of interest to you. I haven't done excuse me, I haven't done PowerPoint slides. I have got a handout, and subject to any administrative problems, I think I could send that to Ceba from a transmission to anyone who wants to receive the notes. As you can see, I'm from Fenner's Chambers, and I've done this webinar for Ceba, and the title is Contested Heritage, Law, Religion and the Slave Trade. I've put my trainer profile on the next page, just so you can see what my background is. I've also put, more importantly, a disclaimer, so that you can't rely on this paper for any purpose whatsoever, except for, of course, the one CPD hour. Now, as I've mentioned in my profile, I've recently been appointed Deputy Chancellor for Southwark, that was last September, and Deputy Commissary General for Canterbury, which is the equivalent position. So I'm fairly new to this area of practice, but it is something that I personally find very rewarding and very interesting. And it has the big decision, I think, that's come up recently has been this decision in relation to the Rustat Memorial. Now, I'm not sure how many people understand the faculty jurisdiction of the Church of England, which is where the Rustat case has arisen. So what I'm going to do is I'm going to do a very, very quick whistle-stop tour on listed buildings. The faculty jurisdiction of the Church of England, which is the Church's own listed buildings jurisdiction. The Duffield questions, that's the principal governing authority that applies when heritage cases come up before the faculty jurisdiction. There is statutory guidance which the Church brought out in January on contested heritage. Then I'm going to have a quick look at the decision and see if there's a way forward. I've also mentioned Q&A. I'd be really delighted if you would put questions in the Q&A happily as we go through. I hope there will be time to deal with them at the end. The reason I'm particularly interested in the Q&A is this is a very new issue. So far as I'm aware, there have only been 2 petitions so far since the Church of England brought out its guidance. One was unopposed, and that was a case that we will deal with, and that was in relation to St. Peter's, Dorchester, but that was uncontested. This is the first contested one, and views differ as to whether the consistory court got it right. So I'd be very interested to hear your views. I've put a section there, is there a way forward? I have a few ideas, but I'd be very interested to hear yours. I'd be very interested to deal with any of your questions, because it seems to me that this is something that It's really important. And we're at the beginning of the process. So now is the time when we've begun to see how it might pan out, to put in our suggestions and hopefully reach some creative solutions. Listed buildings then. And I apologise to all of you who know this already, but I think a lot of people don't know what the faculty jurisdiction is about. They don't know how the decision in Rustak came to be made. And there's a lot of noise in the press, a lot of noise in the Telegraph and the Mail and other newspapers, which to me probably obscures what the issues really are, which it isn't surprising for media and things that they pick up on. So listed buildings, we're talking about buildings which are of special architectural or historic interest. They are typically considered to be of national importance and therefore worth protecting. And what this means that if you happen to live in a listed building or occupy one for work, you will find that you may not be able to put as much as a nail in the wall to hang a picture without getting listed building consent from someone. The list is held by the National Heritage List of England, and it's the only official up-to-date register of all nationally protected historic buildings and sites in England. There are 3 categories: grade 1, grade 2 star and grade 2. Almost all listed buildings fall into the grade 2 category. An awful lot of churches fall into grade 1. What does listing mean? It means that because of the building's significance, the owners need to apply for listed building consent for most types of work that affect, quotes, the special architectural or historic interest of their home. If you want to do something to the property, if you want to take something down, which you could do in a modern home without thinking, take something down, change the roof, put up an extension, you can do that without permission. If you occupy a listed building, you will have to get consent. I've listed here the bodies that you need to deal with when you're considering an application for consent. Local authority planning department, which includes their conservation officer and may sometimes include the county archaeologist. I'm sure any of you who do construction will be familiar with the situation where people begin architectural works. As soon as they've done some digging, they come across some bones or some pottery or something, which is crucial, and yes, the county archaeologist will come out and say the work has to stop until this has been dealt with. And if you've got a large mosaic under your back garden, you may not be able to resume the works. Historic England is a body which may be consulted by local authorities on certain applications, particularly the ones at the top of the list, the grade 1 and the grade 2 star, and also in relation to grade 2, or any of the most serious works. There are also the National Amenity Societies. These are specialist organisations that know something about historic buildings, usually for a particular period. So I've listed some here: the Ancient Monuments Society, the Council for British Archaeology, Society for the Protection of Ancient Buildings. Okay. What we are going to look at, I think it's more recent stuff, the Georgian Group and the Victorian Society, and there's also the 20th Century Society. And I think the thing is to bear in mind that because the building is of architectural interest, that doesn't mean it's old. It can be of great architectural interest because it is of interest, and that could be something made very recently. There is a house with a shark which has got through the roof. Nobody understands how that happened, but that is a listed building because it is of architectural interest. So within the Church of England, we have our own jurisdiction for dealing with listed buildings. Most churches are listed buildings, but they are also, and this is expressly recognised by the law, they're primarily places of worship and mission. So they're not just beautiful thatched cottages which date back to the 12th century, or beautiful coaching inns or something like that, which date back to the 18th. They are primarily places of worship and mission. And this means that they have a special exemption from planning rules. This is under SI 2010-1176, which you can check out if you're so inclined. Now, this gives us the ecclesiastical exemption. And that means that churches and cathedrals don't have to get listed building consent, but they have to have their own system for giving the equivalent. So they don't have to worry about listed building consent under the normal law, conservation area consent, building preservation notices, and various other things. Nevertheless, some of the works that people may want to do, particularly if they're extensive, may be subject to scheduled monument consent. They may need planning permission for some aspects. Building regulations may still apply. Tree preservation orders, that's often a very major issue, particularly large yew trees in churchyards. And sites of special scientific interest, and bat licenses. And the bats are a real problem for some churches. Their offices are full of bats and they can't do anything about it because the bats are a protected species. Now, under Article 5 of the 2010 order, that's the one which applies to the faculty jurisdiction of the Church of England, and that's for churches. Article 6 deals with our care of the Anglican cathedrals, care of cathedrals measure 1990. And there are laws which the Church of England makes in synod, which we'll look at in a moment. Article 7 deals with the scope of the exemption for buildings within the care of other denominations. So it's not just the Church of England. Specifically mentioned are the Roman Catholic Church, the Methodist Church, the Baptist Union, and the United Reformed Church. And they have the same exemption, but whether it's slightly different in scope, because they are not primarily a heritage site, they are primarily a place of worship and mission. Now, the purpose of the exemption is to ensure that changes are regulated. So you can still do things, you can still take things down, change the wooden doors for glass doors, you can take out pews and have a play area and so on and so forth. But what has to be done is there has to be full consideration of all the relevant issues, just as if you were subject to the secular planning laws. But the purpose is to enable churches to balance mission, worship and community use on the one hand against care and conservation on the other. This means that the denominational systems of control, so we have our own system of control, but it needs to be open and transparent. It needs to be demonstrable that churches are doing things in an orderly and lawful manner, and not saying because they have got a parent and toddler group, they're going to rip out some architectural feature which is important and valued and makes the building significant. They have to do it in a lawful and orderly way. The way we do it in the Church of England is that each diocese has a consistory court presided over by a Chancellor, and as a deputy I exercise the jurisdiction of the Chancellor, and that person carries out the balancing exercise as between worship and mission on the one hand and built heritage on the other. And then I decide whether to give the equivalent of listed building consent, and the means by which I do this is a faculty, that's a permission. Our procedures, again, open, transparent, and you can find them on the web. They are governed by the faculty jurisdiction rules, and they derive from the Ecclesiastical Jurisdiction and Care of Churches measure 2018. There have been predecessors to this measure, but the current one is the 2018 one. Now that lists the courts that the church has. Sorry. Like Richard McKee, I'm suffering from a really bad cough. And sets out the church courts and their respective scope and their powers. Now, section 35 is relevant to our consideration tonight. It says a person carrying out functions of care and conservation under this measure or under any other enactment or any rule of law relating to churches must have due regard to the role of a church as a local centre of worship and mission. As a local centre of worship and mission. So what will happen is the vicar and church wardens or somebody else will make a proposal and they say, this will help us serve our parish better. This will be part of our outreach. This is part of our welcome. This will make our services easier. This will make our hospitality easier. So worship and mission, that's the key thing. And just in case you don't know, a measure passed by the General Synod of the Church of England is the equivalent of an Act of Parliament, but it will only relate to matters concerning the Church of England. And once you've got a measure, you can have kind of, which is considered primary legislation, you can legislate by canon. Now, in keeping with our standing as an organisation which is primarily for the benefit of worship and mission, the doctrine of the Church of England is part of our canon law. And the doctrine of the Church of England is grounded in the Holy Scriptures, in the teaching of the ancient fathers and the councils of the Church, I agree with the Scriptures. I'm not going to get into a religious argument now. I'm sure you're aware that there's lots of scope for argument there. But what it means for our purposes is that the consistory court will often refer to the Bible, and often you will find normally just a verse or so, or perhaps a passage, that the judge, the deputy chancellor, will refer to that in the judgment and say this is agreeable to such and such a verse of scripture. And particularly in relation perhaps to suffer little children to me or something like that, it changes something which enables the church to have a better ministry for children, something like that. So frequently that will happen. It's normally only just a verse or a slight reference, and it helps to remind everyone concerned that the church is primarily a place of worship. Now, I don't know what your areas of discipline are, but anyone who's familiar with the CPR, family procedure rules, or the water protection rules will find the faculty jurisdiction rules to be familiar territory. For example, Part 1 deals with the overriding objective, which is something that we're all used to. And the rules themselves set out works for which a faculty isn't needed, because you don't always need permission. Sometimes you can do works without getting permission at all. That will normally be something like works of maintenance and repair. Sometimes you can get works approved by the Archdeacon without having to go to the consistory court. And sometimes you will take advice from what's called the Diocesan Advisory Committee before you start proceedings, and they may say, well, actually, I think this can be authorised under List A or List B because it's routine works or because the Archdeacon's approval would suffice. If you do need to go to the court, they will also give you some guidance on that. Proceedings are commenced by petition, and the rules contain provisions for objecting to a position, for directions to be given for evidence and hearings, as to the conduct of hearings, court's case management powers, costs, appeals, and all the things that we're used to from our ordinary mainstream litigation work. Now, one of the particular things that you need if you are going to lodge a petition for a faculty is you must have these documents in support. So we have to have the Diocesan Advisory Committee's notification of advice, bearing in mind that petitions are normally brought by a vicar and church wardens on behalf of the church. So they want a new rail put in, or they want a screen taken down. They will normally be the people who are pushing us forward. So they know, they're familiar with the Diocesan Advisory Committee. They understand when the church is surveyed every 5 years. They have to produce a document called Statement of Significance and Statement of Needs. This reflects what happens with secular planning law. They will have done that to the Diocesan Advisory Committee, and that needs to be before the court as well. Any relevant designs, plans or photographs, any advice relating to the environmental implications of the works are the proposals, any other documents giving particulars of the works are the proposals, and in certain cases they may have had to be in touch with Historic England or the amenity societies who will have said, I'm sorry, you cannot take these pews out, or you can remove this pulpit, and it will be, or you ought not to. And a lot of the time there will be objections, but sometimes it will simply be a description that helps the court to understand why this particular feature of the building is so important and why it shouldn't be lightly interfered with. So that's really what it's all about. The Statement of Significance and Needs, these are crucial to the balancing exercise that needs to be carried out. And as I say, if it's done properly, you may be able to get a decision at an early stage. They certainly need to be before the court at any contested hearing. And I think that part of the problem in the Rustak case was that the court wasn't satisfied that enough work had been done for the Statement of Significance and Statement of Needs. The Statement of Significance, just as I say, in parallel with secular jurisdiction, so you describe the building and you say what it is, what's it like, and what does it have inside. So you would say it's got a 10th century font, which is the oldest font in Sussex or something like that. You may describe the objects, you may describe the carvings, you may specify who the architect was or who the designer was, why there are special bits of the church. You could also say that, these alterations were made in the 1920s and they are rough and unsightly. Yes, we've used them, but we'd like them to go. And so you have to let the court know what each element contributes to the character of the whole. And if you want particular areas or elements to be changed or removed, you should specify those. You should tell the court how the building's evolved over time. And there have been lots of changes to buildings. Church buildings suffer fires. They have ambitious vicars who put in architectural features that are disgusting or of their time. All these things are relevant to the decision the court has to make. And the Statement of Significance should have a summary of why the elements in the building are important and the contribution they make to the character of the building. So you may have some beautiful stained glass windows, perhaps designed by a modern glazier, or you may have some lead panelled stained glass windows which have been in the church since the 13th century. These are things you have to describe and you have to explain if you want changes, why the changes are appropriate. So then the proposals will be in context. The Diocesan Advisory Committee and other bodies and the eventual decision maker will understand the impact. And it may also help with the identification of alternative, less damaging ways to meet the needs set out in the Statement of Needs. bearing in mind that what we're looking at is changes to a grade 1 listing building where there's a presumption against change. Okay, we're looking at care and conservation, and there's a presumption against change. You have to weigh that up against the church's worship and mission, but there is a presumption against change in a grade 1 listed building. The statement of needs is where you say, this is why we've identified a need which cannot be met without altering something in the church building. That this thing obscures the vision of the view of the choir. This is not convenient when we have weddings. So you have to identify the needs, and the court has to be satisfied that those needs are real. And then you have to satisfy the court also why you say the proposed changes are necessary, and particularly in relation to the worship and mission aspects, because that's not going to be balanced against the beauty of some architectural feature, which is part of the built heritage. You also have to consider other options. Again, as I say, there's a presumption against alterations to a listed building. So you have to be prepared to say, well, we looked at doing X and Y and Z, and they're not feasible, they're too expensive, or they would be too expensive, or they would take too long, or ultimately they wouldn't meet the needs that we've identified, or whatever the reason is. Now, the consistory court is like any other court, so it has regard to precedent, and the most significant of these for our purposes is the decision of the Court of Arches as one of the appeal courts from the consistory court in recent Alban and Duffield, a fairly recent case, and there's been a couple of cases since then which have commented on it. Now, I've set out the facts of the Duffield case, but they're really there for interest and background. I don't think I've got time to deal with those, to deal with the facts of the case tonight. But the key matter of interest for present purposes is that there was an authority, let me see if I can find it, recent Helen's Bishopsgate, which the Chancellor in that case relied on it to refuse the faculty. And what Duffield held was that the rules in Re Helen's Bishopsgate were too restrictive, and the Chancellors needed to be able to be more flexible. So then what they said was this, at paragraph 87. In our opinion, Chancellors should be freed from the constraints of the Bishopsgate questions. We have much sympathy for the view of the Chancellor Maclean in Re Wadsley Parish Church, paragraph 24, that there is a danger of imposing an unduly prescriptive framework on what is essentially a balancing process. I think it's key to remember, because when we talk about a balancing process, we know we're in the realm of judicial discretion. And we know that in that event, the judge can do something that we think is absolutely wrong, but we won't appeal against it. There's no, because the judge wasn't plainly wrong. So we know we're in the realm of discretion. And it goes on, for those chancellors who would be assisted by a new framework or guidelines, we suggest the following approach. Firstly, you should ask this: would the proposals, if implemented, result in harm to the significance of the church as the building of special architectural or historical interest? Okay, so if you want to take up some tiles which were put there in the 1960s and all quite ugly, there might be harm to the building, but it's not going to harm the significance of the building as the building of special architectural or historic interest. If, on the other hand, you want to take out a Georgian box pew, then yes, it probably will. No, it's not just about the building work and the tearing to the fabric and splintering of wood or chipping of tiles. It's about ultimately something that makes this church special is its Georgian pews. But if we take them out, there will be harm. So that's the first question. If the answer is no, there's no harm, then the ordinary presumption in favour of things as they stand is applicable, but you can rebut it. Okay, so conservation is all about keeping things as they are. So our starting point is always, let's keep it as we are. But actually, if it's not going to do any harm to the significance of this building as a building of special architectural or historic interest, then we don't have to worry. However, if the answer to question one is yes, then you have to look at how serious the harm would be. And if you think, depending on how serious you find the harm to be, you would obviously have to have a correspondingly greater justification for carrying out the proposals. And some of them are quite serious. It may be that the church can't be used for something. It may be that there's something is causing subsidence or other structural problems. So you'd have to look and see. But, there may be a real justification for carrying out the proposals, even though you think that the harm would be serious. bearing in mind there is a strong presumption against proposals which will adversely affect the special character of a listed building, will any resulting public benefit, and there's a list of things which are considered to be public benefit, outweigh the harm. So we need to look at things like liturgical freedom. And I don't know how familiar people are with the concept of liturgy, but it is part of the liturgy is the design of a church. That's part of what helps us to worship. It isn't just the words, it isn't just the vestments, it is also the way the church is laid out and things that prompt us to prayer and worship and things which enhance the church as a local centre of mission and worship. So we're looking at liturgical freedom, pastoral well-being. Vicars will often say, I just can't work in this church because of X. It would be so much better. Or you may have a choir who are very frustrated because something doesn't work for them. And maybe it could be something like they need something better to change. But in order to get a better change, we will have to do some structural building works. Opportunities for mission, putting the church to viable uses which are consistent with its role as a place of worship and mission. And that could be a soup kitchen, it could be a parent and toddler group, it could be a group for the elderly. For example, you may find that one of the things people want to do is get rid of steps and put in a ramp. It's those sorts of things. Now, would those sorts of public benefits outweigh the harm? Okay. So these are the things you need to consider when you put in your statement of significance and statement of needs. Obviously, the more serious the harm, the greater will be the level of benefit needed before the proposal should be permitted. And that will be particularly the case if the building is listed grade 1 or 2 star, where serious harm should only exceptionally be allowed. So we have to balance worship and mission against the beauty of the church, the beauty of the heritage, and the harm that might be caused by removing a monument or a memorial or something of that nature. And we have to be very, very careful where it's grade 1 or 2 star, because in those circumstances, you should only get your permission to make a change in exceptional circumstances. There's been a more recent case, 2015 case, where the Court of Arches returned to this. And this is helpful guidance on how Duffield questions can be answered. You can't, I'm so sorry. Now you can't answer question 1. Question 1 is this: would the proposals, if implemented, result in harm? In significance, and of course significance as a building of architectural or historical interest. You can't answer that question, says John the Baptist Penshurst, without prior consideration of what is the special architectural and or historical interest of the listed church. So you've got to look at your church and think, why is it special architecture? Because it's the last remaining Saxon church in our county, because it's the only church which has a rood screen carved by this particular famous Victorian carpenter. Those are the sorts of things. So what is it that makes this place a special architectural historical interest? And that has to be identified. Now, in Duffield, it was that the Chancellor threw into a ministerial failing to identify what was the special character and historic interest of the church as a whole. That is something on which we would expect evidence to be led. So we'd want counsel on either side, or the parties, if often they can't afford representation, to come to church and explain, and we often sit in the church, to come and explain to us what it is that makes this church a special character or historic interest. The particular grading of the listed church is highly relevant. So if it's a grade 1 listed building, your chances of getting a change approved are obviously really low. They're much higher if it's grade 2, but the church will always be the balancing exercise. What about justification? Now, you don't have to prove necessity. That's what Bishop said, you have to have necessity. So justification isn't, we have to have this, otherwise we won't be able to perhaps worship or run a parent and toddler group. Necessity obviously is great if you can prove it, but often it's just really, really important. And you know, yes, we can carry on without, but it's really, really important to us. So you do need to deal with your statement of needs and make sure that the Chancellor really understands why it is that this thing needs to be done. And the questions are directed at the effect of the works on the character of the listed building. Okay, so what effect is it going to have on the character of the building? rather than looking at what alteration, removal, or disposal might do to a particular article. And that, I think, we'll find was relevant in the Rostaf decision. Now, as I mentioned, the Church brought out guidance on contested heritage. This, again, is available on the web if you're interested to track it down. Contested heritage, historic England, not the Church, historic England has a definition, meaning historic objects, structures, buildings, or places where the associated stories or meanings have become challenged. So there is a new version of history, or we've only heard one side of the story. The classic is the one Barbara mentioned of the Colston statue. Well, the narrative for Edward Colston was that he was a wonderful man because he used his money to pay for so many things in Bristol. You know, he founded schools, he paid money for hospitals and all the rest of it. But the downside of that was how he'd made his money. And that narrative was known and it didn't seem to trouble anybody. But now there's a new story or meaning going around saying, but that's monstrous, that's outrageous. That means that it was blood money. So that's a contested issue. And you'll find a lot of people say, don't care, he was a great man. He was a philanthropist, he paid for all sorts of things. You know, there wouldn't be a grammar school without him. You know, thanks to him, children were educated. Thanks to him, churches were preserved, hospitals were set up. But we're saying, no, there's a different narrative. So that's why it's contested. And historically, I'm going to go on to say, the interest in interpretation of our past has never been greater. And when heritage becomes contested, strongly held views tend to exist on all sides. So you will find people, and it doesn't go with colour, and that's something I'll come to in a minute. It's not a black-white argument. There are a lot of white people. The first time I heard of Edward Colston was in a documentary on the radio many, many years ago, I think 10 or 15 years ago, where somebody who was clearly a white woman was outraged at what he had done in Bristol. And there are all sorts of different perspectives that people have, and they aren't aligned with colour. I think that's something to bear in mind. The Church's own guidance focuses on the issue of the memorialisation in tangible form of people or events connected with racism and slavery. This guidance is about a specific type of contested heritage. It isn't, for example, contested heritage which is problematic for LGBT people. It's specifically about racism and slavery. And what it says is the way it's looked at it, there may be principles that could be applied in other areas, but for the moment, it's simply focusing on racism and slavery. It's a 20-page document, but half the pages are only half printed, so it's not very long. There's lots of illustrations, and they do set out principles, processes, and options for people who are dealing with contested heritage to consider. And obviously, some of this may be stuff which never comes to court. It may be that if you are in a cathedral and there's an item that you think needs to be covered up or removed, this is something that you can deal with without coming to court, but you would be able to look at the principles which the Church has provided in this guidance and work through. And there is a flow chart working through to see what's important. They talk about open dialogue, so this may be something that somebody in the Church will raise. So somebody will come to the vicar and say, do you know what, I was looking at the memorials of the day, and this one is to somebody who was, you know, a slave trader, made his money out of enslaving Africans for generations, and I'd like to know whether we can take it down, or, you know, perhaps have a sermon on this subject and reassure people about the Church's current opinion. I've picked out a sentence here. It is important to remember that this is not about judging people in the past by the standards of the present, but about how items of contested heritage and wider issues of underrepresentation affect our ability to be a church for all in the 21st century. So the Church is clearly coming down on the side of inclusion, of welcome, of making sure that people are welcomed in church. But I personally take issue with the first part of that sentence, not about judging people in the past by the standards of the present, because I do not think that that's fair to say we've suddenly become enlightened and now we can see that the slave trade was wrong. I'm sure that people at the time knew that it was an evil trade, and we let them off the hook if we say, oh, well, it's because we're looking at this with 21st century eyes. That isn't the case, and I will deal with that when we come to Tobias Rastak, who was a benefactor of Jesus College in the 17th century. Okay, For the faculty jurisdiction, the guidance is helpful in terms of attempting to justify a physical intervention, such as altering or removing a memorial. What needs to be proven is not principally that a memorial is to somebody, or perhaps donated by somebody, whose views or actions we would now condemn, but rather that the presence of the memorial has a demonstrable negative effect on the mission and ministry of the church or cathedral. We're trying to get away from passing judgment on past slave traders, or people who make their money in a way that's not acceptable, and focusing on, well, does this affect the way our church and cathedral reaches out to people? Does it affect the way people are able to worship when they come into the building? It goes on though, and in the case of a proposed course of action that may be considered harmful to the heritage of a building, you'll remember the harm is the first Duffield question, that substantially the same benefits could not be achieved by a less harmful option. So we're looking at this and saying, does this put people off coming to church? Does this compromise the church? Does this make the church look as if it supports slavery and colonialism? So we have to look at that. Having done that, do we actually need to take it down? Could we just cover it up? Could we put a plaque next to it that would explain? And that sort of thing. Could we have something perhaps in our church literature which explains that this monument exists, but now this is how we feel about it? And actually, I think it would be better if they said, we always ought to have felt that way about it. You know, there's no excuse for us putting this up, even though it was the 19th century. Okay, so you can see there's a balance to be struck between the church's mission and avoiding harm to the building's heritage. Okay, so the guidance is entirely consistent with how the faculty jurisdiction has run and with the Duffield questions. And it's important to research the heritage asset in question, so its significance can be properly understood. So what we're looking to see is, where did it come from? Is it really a slave trade benefit? Tell us about the person who put up the memorial. Tell us about what his background was, what he was up to. Why was this made? And then there's another thing with the Rustat Memorial, which is absolutely a thing of beauty. If you want to look at it as in aesthetically, it's a beautiful thing. It was done by Grinling Gibbons or in his studio, and anything that he created, he was the celebrity sculptor of the time. He made beautiful things, and Rustat was a very wealthy man. So it's a wealthy man able to get the best sculptor of the day to make this thing. It's beautiful to look at. So we have to consider this thing is beautiful as to the church, as to the character of the church, should it go? And there are issues that are raised. This last sentence, I think, is important. The effects of enslavement continue to impact the lives of many UK ethnic minority communities, to whom at best these objects may be reminders of an overcome past, a horror from which we celebrate our extirpation. At worst, for these objects to remain in place with no discussion or interpretation could be taken to imply that the oppression and disenfranchisement that they evoke for many in affected communities is socially and theologically acceptable to the church. I think that is a risk. We should, I think, in some circumstances, be rushing to dissociate ourselves from certain people, regardless of how beautiful their monuments may be. I would also say that this is not personally my reaction to a slave memorial in a church. For me, it isn't about the horrors of the past. For me, it's about total bafflement at the present, as how we can, as Christians, go on saying, yes, we're going to celebrate this person. And so I normally feel just perplexed that people are not more ashamed and not quicker to take something down. I think it's also the case, and it's not a strange sentiment, that we can often look at something beautiful and say, actually, to me, it's ugly, because I know where it came from. I know what produced it. And so I can look at it and I can see that it's absolutely ravishing. The marble is beautiful, the carving is wonderful, and everything else. But to me, although it looks beautiful, and I know it's beautiful by comparison with other similar things that this particular sculptor did, or other similar monuments, to me, this is ugly. I think it would be helpful if the church was able to say, this thing is beautiful. It's a beautiful element of our heritage, but for us, it is ugly because of where it came from. Okay, so suggestions for what you might do. You can make additions to the object or its context in such a way as to appropriately address its contested nature or negative associations. So you might be able to put up an explanatory plaque explaining who this person was, explaining why the monument isn't coming down. You can make a non-permanent alteration, temporary coverings. We'll see that happened in the Dorchester case. You can relocate the object to a place of less prominence, into storage or on loan to another institution. So That was one of the options in the Jesus College case, was to remove it to another location, but there wasn't actually another suitable location within the college. That's partly because the monument was 8'6". It's an absolutely massive monument, and finding another place which had to be indoors, it couldn't be outdoors, it's not weatherproof, and in any case it would be vulnerable to vandals. So you've got to find another indoor setting for it. And yes, a chapel is big enough to take it, but not many other parts of the college were. You could put it on loan to another institution, and that work if you put it in a museum where it can be fully explained, that can be an option. You can dispose of the object. If it is really beautiful, like the Rustat Memorial, I think that's going to be a difficult one for the church to approve. To say we should smash up this beautiful piece of heritage, it's a very difficult one. Permanent alteration. There are ways of erasing offensive language. We'll see that there was temporary erasure in relation to the fortress of thing and destruction. So I think it is difficult. One thing that the guidance acknowledges is that contested objects will continue to exist. And it acknowledges that a different generation in the future may take yet another different view of that particular piece of heritage. And perhaps it's advisable that things shouldn't be disposed of or destroyed. They should be left so that future generations can look at them and perhaps reconsider them to a different conclusion. Okay, Rustat. Now, I mentioned there were 2 petitions. There is a very interesting article in a journal called Law and Religion. Again, it's available online. And what it says is that, which I think is probably true, when people go to a historic parish church, they'll often spend a lot of time looking at the memorials, and this will prompt reflection. And that's quite different from seeing the memorial in a museum. So, and that's obviously a question of spiritual reflection. Particularly if you see a memorial to somebody who's really a worthy human being, that may be an example, to somebody who lived their life for the benefit of others, really followed in the footsteps of Jesus Christ, and maybe something that provokes positive thoughts in somebody who's reflecting on it. Now, I'm deal first with the unopposed petition, and you'll see why nobody bothered to oppose this. And this happened uncontroversially, relatively uncontroversially in 2020. And this was a man called Dr. Gordon, and the monument itself, actually, the monument on the face of it expressly celebrated what he had done in Jamaica as a slave owner. So it is really a blatant case. On his return to Jamaica, where he had resided many years in universal esteem, so everybody thought well of him for being a slave owner, he was signally instrumental in quelling a dangerous rebellion in that island in the year 1760. A large body of, and I've starred this word, and that was the word which the Archdeacon ordered should be cut up, whom his bravery had repulsed, finally yielding to their confidence in his humanity. This monument is erected as a mark of affection to the memory of the best of brothers. Now, you can see why that's contested. What we might say now about a slave rebellion, what the slaves thought about that rebellion, is likely to be quite different from what this monument says. So you can see where the contest would lie. I also wondered about this, to their confidence in his humanity, because obviously he triumphed over them. And I just wonder whether there was really humanity after that, or whether he probably, as a typical slave owner, would have been brutal to the people that he had conquered their rebellion. So that would, for me, provoke some really difficult thinking. I think there'd be a lot of people for whom that would be the case. I was saying not restricted to Black people. I think there'd be a lot of people of goodwill who would find that really difficult to see this thing elevated in the church and this monument being celebrated. And as I say, there was no difficulty with the faculty for removal. Nobody opposed its removal. Rustat was a bit different. I've put in here the wording of his memorial, and there's a picture coming up on the next page. So Tobias Rustat, Yeoman of the Robes to King Charles II, he was a courtier, he was moved in the highest social circles, whom he served with all duty and faithfulness in his adversity as well as prosperity. Because when Charles II was in exile during the days of Oliver Cromwell, Rustat was at the king's side. The greatest part of the estate he gathered by God's blessing, the king's favour, and his industry. He disposed in his lifetime in works of charity, and found the more he bestowed upon churches, hospitals, universities and colleges, and upon poor widows and orphans of Orthodox ministers, the more he had at the year's end. So he was stressing that he had put he had money. He thinks he got it by God's blessing, the king's favour, and his own hard work. But he used it for all these good things, and he found that the more he gave away, the more he had at the end of the year. Neither was he unmindful of his kindred and relations in making them provisions out of what remained. He died a bachelor in March 1693, aged 87 years. So what he had was he lived as what he would have regarded, and what probably most of his contemporaries would have regarded, was a worthy life. And in fact, the word worthy life is something to do in the judgment. Everything down to what remained, he had written himself. This was not a memorial that somebody put up to him after his death. He wrote his own epitaph. And what he did was, he had this thing, and there's a picture of it showing just how big it is. And he had, and the top bit here was a bas relief of his own self. So there's an image of him with his long Charles II wig, and then beneath it there's the wording that I just read out to you. And he had this in his house for 8 years before he died. And I can just imagine him walking downstairs and seeing this thing every day and patting himself on the back. Now, the Bishop of Ely referred to this as self-vaunting. And there is quite a lot of self-congratulation in this. It's not the sort of modest, yes, I've done my best in life, or by the grace of God, I've been able to help people. There's a real kind of self-adulation in this, and I think that partly is part of the problem. So what happened was, Jesus College, they reviewed all their slavery connections, and they presented a petition seeking permission to remove this memorial from the college chapel and relocate it to another part of the college. Initially, they wanted to put it in a cupboard somewhere because they were so disgusted with it. But they decided, and Rustak funded so much at Jesus College. He didn't just have, he's the biggest benefactor probably of the college, and enabled its survival probably in the 17th century. So he really was a major donor. They wanted to hide it away, but it was then said, no, come on, you've got it. This is too special. Brennan Gibbons made this. It's beautiful. It's a thing of beauty. You can't just stick it in there. So they tried to find other places where they could put it. And the basis of their petition was that Rustak's investment in companies connected with the slave trade created a serious obstacle to the chapel's ability to provide a credible Christian ministry and witness to the college community, and a safe space for secular college functions and events. If I take you into the picture, you can see that it's a big space, and they have concerts and other things going on in there, as well as church services. The Deputy Chancellor refused to grant the faculty. He said that the removal of the memorial would cause considerable or notable harm to the significance of the chapel as a building of special architectural or historic interest. If people come to that chapel as tourists, for example, partly because the Rustak Memorial is there, and because it is so lovely, it enhances the chapel. Its beauty, its aesthetic beauty, leaving to one side what I said about something which looks beautiful, in fact being lovely. If you just look at it, it's a beautiful thing, and that enhances the church, and then it dates back to that period. Grinling Gibbon is very famous. There aren't many of those of his memorials in Cambridge. There are more in Oxford. There's not many in Cambridge, so it's all around it's special. Now, I've dealt at paragraph 4, section 4, with the legal underpinning of the judgment, but I'm not going to take you through that in detail because it's simply the Duffield questions which we've looked at in the past, and all the stuff that I've been stressing about worship and mission on the one hand and preserving the built heritage on the other, but the text is there. But the conclusion is here. Despite the powerful and emotive evidence advanced by the college, and I take issue with that, I don't think it was about emotive evidence at all. I think it was an issue of justice. So the court decided that the removal of the memorial was not necessary to enable the chapel to play its proper role in providing a Christian ministry. The public benefits hadn't been made out to that level of being exceptional, because the permission will only be granted in exceptional circumstances. The relocation of the memorial to an exhibition space, because they had an exhibition space in mind, to exhibit it somewhere else and to create a space where it could be exhibited, isn't the only or the most appropriate way of dealing with it. And the judge repeated paragraph 6 to 9. I personally don't agree with these paragraphs 6 to 9. I think that the judge was wrong in this case, but within his discretion. So I don't think necessarily an appeal would lie from it. And I'm sure people are aware that Jesus College have chosen not to appeal. Applying the Duffield guidelines, the judge was satisfied that the removal of the memorial would cause considerable or notable harm. That was eventually conceded by the college. The college, therefore, strictly yes, according to Duffield, should demonstrate a clear and convincing justification for the removal, and he wasn't satisfied the college had done so. And the suggested justification is clearly expressed, but he didn't find it convincing. I'm not satisfied the removal is necessary to enable the chapel to play its proper role in providing credible Christian ministry and witness. Not satisfied that the relocation to an exhibition space is the appropriate way of dealing with the difficulties that Rustat presents. I find this bit very difficult. He goes on at length about how awful, evil, utterly abhorrent, and all the rest of it slavery was, but then goes on to exonerate Rustat. And to me, it seems unbelievably technical, because it's based on the fact that Rustat only realised his investments in the Royal African Company in May 1691, some 20 years after he'd made his gifts to the college. But the report of the experts agreed that Rustat had already been investing in the company at the time he made his bed. So he was an investor. It's just he hadn't yet had a return on his investment. But what was he investing in? No, the Royal African Company, the Royal Adventurers, these were companies which invested in the slave trade. He was already invested in the slave trade. Does it matter that he hadn't yet made any money? And there's a statement from the Master of the College, first black woman to be a Master of the Cambridge College, saying, yeah, I don't really care whether he made his money or not. You know, he was investing. And the evidence was that he had invested quite heavily. And was heavily involved in the management of those companies. It wasn't just that he had money in there and left it and still, well, I'll wait until that matures. He was actually involved in the management of those companies. I also acknowledge, says the judge, that there is no evidence that Rustat ever repented for his involvement in the slave trade, unlike, for example, the Reformed Slave Ship Act and the Reverend John Newton. We know Amazing Grace and How Sweet the Name and all those things. So those were the decisions. And then he was satisfied that the answer really is that there should be some sort of explanation. This wouldn't wash with me personally. I don't care how many explanations there are of Rustat. It's not going to convince me that his memorial is appropriate in a chapel, which is supposed to be a holy place. Primary purpose is for worship, but that's a personal opinion. I also took exception to paragraph 9, because this is the safe space issue, and this is obviously the sort of language that the younger generation, particularly the students, would use. And he says, you won't always feel comfortable in a chapel. If that were true, you'd have to do away with the image of Christ on the cross, or images of the martyrdom of the saints. I find that difficult as well. This is a memorial written by the man himself to his own glory. I think that's rather different from an upsetting image of Christ on the cross, or an upsetting image of St. Edmund, who is a local saint who was shot through the windows. And then there's a little sermon on forgiveness, which I didn't agree with either, but that's a matter of theology. So some quick observations in the last 3 minutes, then I think we can have a little while for questions. I think it was an exercise of discretion, so you can't say that it was wholly wrong, therefore it's difficult to appeal. I think that the court was just too specific about this money, and it said, well, since his money didn't come from the money that he gave to the college, didn't come from the slave trade, it's kind of entirely separate from the money which did. And I think that's really a concept from secular law, commercial law, trust law, where we're used to ring-fencing different funds and not mixing funds. I don't think it really works for a Christian. I think it does leave the impression that Rustat's activities are socially and theologically acceptable to the church, and I think that's a really big risk. I think that is enough for me to say that it's compromised in its work and witness. The worthy life, I don't think that should be accepted at face value. It's difficult to see how you can make a moral separation between the ways he led his life. You know, he was one man, and I think when we are judged, when we judge ourselves, indeed, as Christians, we don't separate ourselves. Well, I'm okay because I can bake, but I'm really bad because I beat my children or something. You can't. You are one person, and you will judge as a whole. But he did build this enormous memorial. He enjoyed it in his home. And he obviously, when he left it to Jesus College, he hoped it would be there forever. So it's difficult, I think, to conclude that he ever questioned his own righteousness. And it is said, these submissions were accepted, that he was in, what could he do, poor man? He was a courtier. When the king said, you must invest in my companies, he had no choice. I can't be doing that. For me, that is just not an acceptable defence. Then there's a huge monument also to Archbishop Cranmer, which was put up in 1912, so obviously centuries after Cranmer had been at Jesus College. And it's that you aren't going to get rid of that one, so why should we let you get rid of Rustats? I can't understand that reasoning. I don't think you can say, well, we're not going to let you have success on petition A because you could have made petition B, whose success is very doubtful, and because you didn't, you're a hypocrite, and therefore you can't have relief on this claim. I just don't understand that. There was also allegedly investing in China, which might be the oppression of the Uyghur minority and possibly modern slavery. And I just can't see how that's right. I also think this is a kind of what you might call an all sins matter defence. We're all sinful, therefore we can't tackle the sin of this man. I just don't follow that reasoning. I also don't accept that we see things now differently from the way we saw things then. There's this quote, the past is a different country, they do things differently there, which is the first line of LP Hartley's book, The Go-Between, and a lot of people of my generation read that book and rely on that. But I don't think that that's true. I think if they did do differently, they read the Bible more, so he's got less excuse than us. And some cases on slavery were already being heard by the English courts. That's quite apart from a papal bull from 1537, which condemned the slavery of indigenous peoples when the Spanish and Portuguese found them in the Americas. So there's lots of things there to consider, and I would very much like to hear what your views are. But it seems to me that law and religion need to rise above what you might call woke and anti-woke debating points, because that seems to me the places on which the case was argued and won and lost. And we do need to find a better way. I've suggested that obviously there's no appeal, so there won't be a change in this particular case. I think we need to consider what the monument is for. Is it a monument to wealth, a monument to vanity? Is it a monument to cruelty? And as I say, beautiful though it is it really ugly? Where should the church's energies be directed? Should we be looking for ways to exonerate someone, or should we be more focused on saying, well, we accept that he was an evil man. The real issue is perhaps the church's position in not condemning him. I also think that there should be perhaps a theology of wealth, which would be able to set slave wealth in context. So it wouldn't necessarily focus on slave wealth, but obviously of the different types of wealth that people have, which Jesus says we should give away, and he'll look at the rich young man, you will love him, you'll say he's faithful. Please say no, but you still give all your money away because it stands between you and your salvation. If you want to be perfect, you have to give your money away. I think if we develop the theology along those lines, we would have better tools for determining I'm sorry, I just got distracted slightly by a comment. I must apologise, I think caught up with a time difference. Mr. Talk just caught the end of the section on the Gordon Monument at Dorchester. My understanding is that the Dorchester case has not yet been determined by the Chancellor. It is with the Chancellor for determination. If that's the case, then I apologise. What I read in Law and Religion was the fact that it had been that the faculty for removal had been granted and it was going through on the nod because it wasn't opposed. But if that's not the case, and obviously there is an issue there, and I would just have to double check and see what the current position is. It is, I think, a fundamentally different type of monument from the memorial to Rustat, because it celebrates activity as a slaver, which Rustat doesn't. Rustat's memorial celebrates him, if I can take you back to the wording, it celebrates him as a benefactor, as somebody who had lots of money and used it to do lots of good. The question for me is really whether he did it so that men would see it, as opposed to his right hand not knowing what his left hand did, such that he's had his reward already. Okay, any questions? I haven't seen anything in the Q&A. Are there any questions that anybody wants to raise or comments they'd like to make? On such a controversial issue, I can't believe nobody's got any comments.
I think you've stunned us with the comprehensiveness of your talk. You've covered everything. including
No,
questions
but I haven't got
that we
any answers. I haven't got any answers. So I'd love to hear from people if they have got comments. Do they think that the Rustak Memorial should have stayed? Do they think it should go? How do they think the church should deal with these issues? What's the morality of them? What's the legality of them? I think they're really challenging questions, and I would love to hear from anybody who's got views on it.
They are, but you've also made it clear that they're actually very difficult ones as well. There are two sides to it.
Yes, I mean, I haven't got any answers. I'm hoping that somebody out there has.
None of us have.
I think the thing is that the guidance is there, and the church has wrestled with these difficult issues, and I think that the theology of forgiveness is inappropriate. I can't forgive Rustak. It's not my business. Rustak wasn't sorry. He hasn't asked for my forgiveness. He probably didn't think he needed. I think it's an unhelpful concept. But what do we do with people like this? Really lots of money. And he used it for churches, hospitals, universities, poor widows and orphans.
Yeah.
And he said the more he gave away, the more he seemed to have. So is he a bad man? Was he a good man?
That's a problem with a lot of these, though, isn't it? Causton is the same. Even Baden-Powell's Scout movement.
Oh, gosh. And some of the things he did in Africa were awful.
They are. But then there's the Scouts.
Yes.
It is a really difficult one. And you've highlighted for us the great difficulties in it that many of us may not have thought about. Thank you very much for that talk, Araba. I see that.
Well, I hope it was useful and interesting.
Yes.
If you get hold of me, you can just look me up on the web and send me an email in Chambers, and I will try and answer any questions.
What do you think Jesus would say about a monument erected to another human being in the temple of God?
I think that if it was a saint, as the judge considered, if it was a saint who had laid down their life, who'd been martyred, I don't think it's a problem.
Yeah.
Where it's somebody like this, who, bear in mind, wrote his own epitaph, he gave others to praise him, he praised himself. To me, that is somebody doing his alms to be seen before men. And I just can't see it as anything but a monument to vanity.
Yeah. Yes, he's a self-publicist, isn't he?
Yeah. And he wanted us to know it 4 centuries.
Yeah. Yeah.
He didn't just want people to know it at the time. He created a memorial that he knew would stand the test.
Yeah. Absolutely right. Well, lots of people agree with you, and lots of comments are on the sidebar as well. It was a great presentation. Thank you very much for that. I truly enjoyed it very much, as I did all the other presentations, even the one that I read. Can I say a big thank you to you, Araba? I know Richard has gone, but to Richard and also to Melissa on behalf of Ceba. And can I thank all the participants who attended as well?
Yes.
If you're interested in more talks, could I invite you to look on the Ceba website? That's ceba.uk. And also the flyer has got details of the Honorary Treasurer and Secretary, Michel Aslangel, and you can contact him directly. If you do have questions that you think of afterwards, because we often get this, contact Michelle and we can forward them to Araba and the other speakers for you. Araba said that she'd leave us a copy of the handout, so hopefully Michelle will arrange that if you've left him your email address. His email address is on the flyer, so he can send out a copy to you. That's very generous of you, Araba. Thank you very much.
No problem. Can I just say, I've seen a question from Eric Anderson.
Right.
And to say, I don't think this case would go to a regular court because of the ecclesiastical exemption. And if it falls within the faculty jurisdiction of the church, then it won't be dealt with in an ordinary secular court.
No.
I'm just checking that there's nothing else.
The reason Colston was actually it was a criminal offence that was committed.
It was a statue outside in the world, wasn't it?
Yes, and then it's they raised a novel defence in a criminal case.
Yeah, I mean, I have to say, if somebody went into the chapel and tore it down, this is one of the problems why they couldn't just relocate it to an outside wall. If somebody went into the chapel and tore it down, then they would have been done for a criminal offence.
Yes, exactly. Yeah. Yes, quite.
That wouldn't fall within the church's jurisdiction.
Yeah.
That would come before you, Barbara.
It would, yes.
In the Crown Court.
I won't say what I might give them or not. All right, thank you.
Well, you might have to depend on a jury. The jury might not convict.
Yes, quite. Well, as happened in Colston, rather surprisingly.
Yeah. Listen,
Anyway,
I've had
thank
a
you all
couple
very
of
much.
requests for
Yes.
the handout, but I haven't got email addresses.
Well, if you contact Michelle Aslangle, whose email address is on the flyer, he's
Yes.
the Ceba treasurer, he'll make sure that you get a copy of Araba's handout, which
Okay, yes,
I
I will send
assume
it to
Araba.
him then, and then
Yes,
anybody who
please.
wants it can contact Ceba and get it from him.
Yes, please. That'll be great. Thank you very much. I'm certainly going to ask for a copy of it.
Okay.
Thank you. So our next talk in this series, for anybody who's interested in joining us, is by Lord Justice Dingemans, Court of Appeal Judge. It's at City University, so it's face to face. It's not on the. It's not a webinar, and it is English law in the digital age. Another free entry event. 5:30, 11th of May, City University Law School. And that is Sebastian Street near Northampton Square. Angel, I think, is the nearest tube station. So I hope we'll see many of you attending that session as well. Thank you all very much.
There's a question there, open to students as well as practitioners, Barbara.
Yes, it is. It's open to students and practitioners, everybody, the event at City College, to be followed by refreshments. I think the students get a special surprise if they contact Michelle Aslangle. But it is open to everyone, right? Including non-City University students as well. Good. Look forward to seeing you all there then. Thank you very much, Araba.
Well, thanks everyone. I've really enjoyed it tonight and I hope it's been useful.
Definitely has. Thank you.